In this video, you're gonna watch me cross-examine my wife, because if you can cross-examine your significant other successfully, then you're gonna go kill it on game day. But unfortunately, my wife, she's a lawyer and she knows all my tips and tricks. So at the very end of this cross-examination, you're gonna see a major blunder of mine. Okay, here is your big warning. Before you watch the remaining portion of this video, if you haven't watched the direct examination already that's sliding above, I highly recommend you do so because, as I always recommend, the cross-examination needs to be narrowly tailored in response to the direct examination. In other words, if you haven't watched the direct, you're not gonna have the context necessary to understand what's going on during the cross. But for those that have watched the direct, here's the cross. Detective Zane, during direct examination, you talked about a tiny scope, correct?
Yes.
And it's your job as the lead detective to look at the full scope of things, right?
Yes, all the evidence.
In fact, you shouldn't reach any conclusions or determinations just looking at that tiny scope, right?
Correct.
And we can go so far to say that you shouldn't reach any conclusions unless you conduct a full investigation, right?
Yes.
That requires you to look at all the facts,
Yes.
all the evidence,
Yes.
before you reach that conclusion that you ultimately tell the jury, right?
Yes.
So one of the conclusions that you ended up reaching involved the rate of travel that my client was traveling that day of the incident, right?
The rate of speed, yes.
Exactly. And you reached the conclusion that my client was speeding, correct?
Yes, based on our investigation, we were led to believe that Mr. Spector was speeding that evening.
But you have no idea the exact speed that my client was traveling, right?
No, I don't.
And you have no idea what the speed limit is on that road, do you?
Off the top of my head, no.
And so you don't know with any particularity whether or not my client was actually speeding that day, correct?
Beyond what our investigation resulted in, no.
So let's go ahead and continue to talk about the investigation. And I want to cover the Impound investigation that occurred. In particular, do you remember testifying to finding a beer bottle?
A broken beer bottle, yes.
And that broken beer bottle was in fact a bottle.
Yes.
And I know that sounded weird, but it wasn't a broken can, right?
No.
It was just a simple bottle, right?
Correct.
And that was in the back of my client's vehicle, correct?
That was where it was found at the impound lot, yes.
But you didn't find it under the driver's seat?
No.
You didn't find it under the shotgun seat?
No, as I said, it was in the back of the vehicle.
Now, whenever you were investigating this vehicle, you also found the napkin?
Yes.
And the napkin stated point after pub?
Yes.
And that took you to point after pub?
Correct.
And while you were testifying on direct examination, you stated that you went to point after pub in order to see if there were any witnesses, right?
To see, yeah, we were trying to see if Mr. Spector had been there the night of the wreck, or if this was from 2 weeks ago, 3 weeks ago.
But your goal in going to point after pub was to conduct your full investigation, right?
Continue the investigation, yes.
And you stated that required you to go talk to witnesses, right?
If there were witnesses, yeah, we were trying to figure out if anyone there had seen him that evening.
But in reality, you only spoke with one person, correct?
That was the person who was, I believe, serving them, so yes.
But that was Miss Paulson, right?
Correct.
And you testified to Miss Paulson telling you that some of my client's friends were there, correct?
Yes.
And you also testified to the fact that some of my client's coworkers were there, correct?
I believe that's correct, yes.
Did your investigation show you that they were the only ones there?
Can you rephrase?
Did your investigation result in you determining whether or not they were the only ones there, or whether or not there were additional patrons there at the bar?
Like in the entire bar?
Yes.
I don't think we asked who else was there beyond speaking with the staff.
So let's talk about this full investigation you conducted. You didn't at any point in time talk to any of my client's friends that were there, correct?
No, I don't believe we did.
You didn't talk to anybody at any point in time, such as my client's coworkers that were there, correct?
No.
In fact, the only person you spoke to was Miss Paulson, right?
The next day, yes.
And your testimony and all the information you gathered from the point after pub investigation is solely from Miss Paulson.
To the best of my recollection, yes.
And at no point did you ever decide to reach out to my client's friends and or coworkers, correct?
I don't believe we spoke with them, no.
Can we agree that had you spoken to my client's friends and coworkers and their story would have been different from Miss Paulson, that potentially would have changed your conclusions in regards to Mrs. Paulson's statements?
Potentially, but I don't think anything Miss Paulson said was particularly hurtful to Mr. Spector. She confirmed he was there. She provided the receipt from his purchase that evening, and she informed us at the time he arrived and he left.
But you agree that if, let's say there was a particular fact that each and every friend and coworker could potentially disagree on with Miss Paulson, that would have changed your analysis, right?
Potentially, as you so put it.
But in reality, you never reached out to him.
I don't recall that we spoke with them, no.
Now let's talk about the scene of the accident. You stated that you saw parts of Mr. Spector's car on the northbound lane, right?
Well, we saw what we believed to be was his hubcap and metal parts on the ground. At that point, we didn't know if they were part of Mr. Spector's car or not.
But at some point, your investigation concluded that those parts were part of Mr. Spector's vehicle, right?
Our technicians did, yes.
And those parts were located on the northbound side?
Yes, if I remember correctly.
And that's the opposite side where Mr. Pearson was traveling, correct?
Correct.
And those parts were located beyond where the pothole was located as well.
Correct.
In other words, those parts were located north of the pothole, right?
Yes.
And which is before my client's vehicle went over the median, right?
I can't determine that conclusively because those parts could have fallen off and been thrown across the median. So I don't know if they fell down and then he went over them, or if the parts fell off in front of where he actually went across the median. I don't know the answer to that.
Did you find any parts on the other side of the lane of travel? In other words, the southbound side?
No, but that's not what I'm saying. I'm saying after the impact on the southbound side. So after he effectively killed Mr. Pearson and went flipping over, I don't know if pieces from Mr. Spector's car went flying back across to the north side. I don't know how those pieces got to that part of the road. Does that make sense?
But just to be clear, at no point in any area on the southbound lane did you find any car parts that were part of my client's vehicle?
Beyond his actual vehicle?
Correct.
Correct.
And the only parts you found were on the northbound lane?
And the median, yes.
And you didn't investigate what could have caused those parts to have fallen off?
Our technicians looked at those parts and would have reported if it was a contributing factor.
So your analysis of those parts was based solely on the technicians?
On their information and the trajectory of the car, everything. We put it all together.
But you never investigated the parts?
Beyond that they came from his car, if they were part of the steering wheel or something, we would have been able to determine that.
Let's talk about the steering wheel then. Did you ever investigate prior to being notified of the tie rod, that actual tie rod? I'll rephrase that. I'll strike that and rephrase that. Did you ever investigate while the vehicle was impounded the tie rod?
I don't believe so, no.
and you never, while it was impounded, investigated, let's say, the brakes.
I don't know if our technicians did or not.
So you have no opinion for this jury on whether or not there were any issues with the brakes.
Correct.
And at any point in time, did you ever investigate, let's say, the tire tread?
I don't believe so, no.
So you have no opinion to this jury about whether or not the tire tread could have contributed to this wreck?
I don't think that it did based on the way Mr. Spector maintained his car. I don't think that it did, but I do not have a professional opinion on the tire tread, no.
It wasn't until you went to Mike's garage did you finally look at the tie rod itself, right?
After Mr. Spector's team reached out saying that they thought this was a factor, no.
And just so it's clear for the jury, your technicians found markings on the tie rod that indicated the tie rod had been cut.
That suggested so, yes.
I'm a little confused on the answer, so let's just make sure it's clear for not only me but for the jury.
Mm-hmm.
Your investigation involving your technicians showed that the tie rod had markings indicating that it was cut, correct?
It appeared like someone had sawed it down, yes.
And you also agree that the tie rod was broken during the accident itself, right?
That's my opinion, yes.
And your opinion is based off of the investigation you conducted, right?
And the information that was provided, yes.
Now, you were also made aware of the possibilities of the tie rod being cut by a person, right?
Yes.
In fact, you were informed that the tie rod was potentially cut by somebody named Lewis Litt, right?
That was an alternative theory presented, yes.
But at no point in time did you ever reach out to Lewis Litt.
No.
At no point in time did you ever give him a call.
No.
At no point in time did you ever show up to his work.
No.
Instead, you made the decision not to reach out to Lewis Litt.
Correct. This information was brought on so far after we had been investigating that it just seems odd. I think you need to be a bigger kind of fish to fry than Mr. Spector for me to believe that that was the cause of this wreck.
But you have no evidence with respect to why somebody potentially like Lewis Litt would cut a tie rod, right?
No, I do not.
You don't know any potential motives that Lewis Litt would have in potentially cutting the tie rod, right?
Correct.
And that's all because you didn't at any point in time investigate Lewis Litt.
Beyond the information that Mr. Spector's attorneys provided, no, we did not.
Okay, let's go ahead and stop here very briefly. Don't go yet because we're not done. At this point during the cross-examination, I should be done. I've made the points that I want to make and I feel good about it. I've ended on a strong note and I have points that I can go ahead and reiterate and emphasize during closing argument to attack the testimony of this particular witness. But there's one final point that needs to be made, not to the witness, not to the jury during closing, but to you, the viewer, which is to never have the Scooby-Doo moment, to never ask one question too many. If you don't know what I'm talking about, here's a video explaining just that, and in this video is an example of just that. Because whenever we pop back into the cross-examination, this final series of questions, you're going to see me basically be done, but decide, yeah, I'm gonna go ahead and take one for the team, take one for everyone watching right now by looking down, trying to figure out what question should I ask next as that Scooby-Doo moment. Then I look up and I ask it, and my wife takes total advantage of it to where I'm floundering, it doesn't look good, and the overall cross-examination does not end on a strong note. And that right there, friends, is asking one question too many.
Correct.
And that's all because you didn't at any point in time investigate Lewis Litt.
Beyond the information that Mr. Spector's attorneys provided, no, we did not.
And we can agree that had you reached out to Lewis Litt and he said, yeah, I cut the tie rod, that would have some effect on your investigation, right?
Well, it probably would have prevented him from ever driving, so he wouldn't have hit Mr. Pearson. But I agree, it probably could have had some effect
On your investigation.
on the entire wreck.
But that's not what I'm asking. I'm asking something a little bit more simple. If you were to have called up during your investigation with Lewis Litt, and Lewis Litt would have just absolutely confessed to cutting the tie rod, that would have affected your ultimate conclusion, correct?
I can't say conclusively yes, because if he had hit the pothole and hadn't been intoxicated or hadn't been driving at a higher rate of speed, then he would have been able, my opinion is that he would have been able to maintain control of the vehicle.
But the tie rod's connected to the steering wheel, right?
Correct.
The tie rod is what helps the steering wheel connect and control the wheels, right?
Yes, that's part of the entire car controlling that, yes.
And so if the tie rod is broken, then there's no way for Mr. Spector to be able to control the car.
Well, how would he have gotten to that point then?
Well, the question is really how, and I'll strike that. You don't have any evidence in respect to Lewis Litt potentially cutting the tie rod, right?
I don't have evidence one way or the other besides Mr. Spector's attorney's theory that he did.
And that's because you chose not to conduct that investigation.
We were provided with the information and we did not think that it was relevant to our investigation.
I'll pass the witness. So I intentionally tried to ask one question too many, just to show that as an example, which puts me in a tough spot.